Today is April 20th, 2025. Today, we offer another report from our friends at the League of Restorative Justice. Their previous work explored the 6 elements of fraud that must generally be met before a conviction for fraud can be properly returned by a jury. After that, the League explained how important it is to fully understand the terms of an agreement if you wish to avoid possibly catastrophic consequence that could result if you fail to do so. The presentation today is a tragically fascinating exploration of how civil and criminal charges were filed in U.S. federal courts against Oasis International Group, its business associates, partners, and in particular, its CEO. Charges that were based on misunderstandings and misrepresentations of the company's structure and operations, but more importantly, upon terribly misconceived and unfounded presumptions about its relationship with the lenders who provided funding to it. The League will illustrate for you the true contractual nature of Oasis' relationship with its lenders, and why an accurate comprehension of that relationship is absolutely critical to understanding Oasis's business activities. The informational void created by ignoring the contractual relationship between Oasis and its lenders left room for the Commodity Futures Trading Commission to act as though Oasis's operations were within its authority. That groundless assumption resulted in the agency filing a complaint that caused Oasis to be prematurely shut down and lose all its assets without a trial. It also resulted in the CEO being sent to prison on evidently baseless charges that were augmented by what appears to be grievously ineffective defense counsel. As you'll see next, the tragic absence of due consideration for the lender's promissory note agreement and disclosures seems be the unfortunate source of all the tragedy and loss that the people involved with Oasis have been experiencing over the past 6 years, as the original case filed in April 2019 continues making its way through the courts even now.
Under American law, a defendant has the right to confront the witnesses against him. The Sixth Amendment to the United States Constitution protects this right, but it applies to criminal cases, not civil ones. We don't know who initiated the investigation resulting in the civil complaint against Oasis, but it's believed that someone who lost management control over a lender's investment fund after it was moved to Oasis contacted the National Futures Association, the NFA, and asked them to investigate. And that spiraled into the creation of several federal cases being spun out of the original civil one. In another video, we'll explore in more detail what happened, how, and why the CFTC filed the complaint that so devastated Oasis lenders and others associated with the company. All of the Oasis cases stand like the legendary Colossus of Rhodes, astride a sea of hypotheses and illusions upon 2 legs composed of unsupported presumptions and unfounded allegations that wholly constitute the imaginary substance of the cases. Unlike the real Colossus, which stood 108 feet high as it famously straddled the Rhodesian harbor centuries before Jesus was born, the legs of the Oasis legal Colossus were manufactured out of imaginary materials. Because American justice, if it may remain such, must stand firmly on facts and not mere presumptions, hallucinations, and unsupported assertions, it is our objective to show how those 2 fabricated limbs were concocted. In a preceding video, we showed that by virtue of the promissory note and agreement, necessarily signed by every contributor to Oasis International Group, lenders had no share whatever in any investment made by Oasis through the use of their loans. The first leg of the Oasis Colossus, which undergirded both the civil and criminal charges, was built upon allegations that Michael DeCorta and company defrauded Oasis lenders. But those allegations were not established with factual evidence. They were simply planted with objectively false and unproven presumptions that unfortunately provided sufficient ground upon which to open the civil case in the Middle District Court of Florida in April 2019. Since lenders had no contractual interest in Oasis investments, they clearly could not have been defrauded by the gains or losses accrued from those investments, as alleged by the CFTC and Department of Justice. Without the perpetration of a fraud, Michael DeCorta should never have been convicted and sent to prison. As we shall later explore, it was only through the abjectly ineffective assistance of his defense counsel and the deceitfully contrived manipulations of the prosecution that he was. In this video, We will identify the makeup of the second leg underpinning the fictional colossus standing over the Oasis cases, which was entirely fabricated from the misrepresented ownership of funds loaned to Oasis. Specifically, we will establish that the funds Oasis invested in forex trading, real estate properties, precious metals and businesses were its sole property, the disposition of which was wholly and exclusively granted to it under the terms of the agreement and risk disclosure. Without any lender having claim as an investor, no commodity pool could be formed, and without a commodity pool the CFTC had no authority, presumptive or otherwise, over Oasis's activities. Thus, as we stated before, the terms of the Oasis Promissory Note and Agreement, including its agreement and risk disclosure section, offered the most powerful but shamefully overlooked defense for Michael DeCorta against the criminal charges brought against him. And as we'll explain in this video, they provide a perfect defense against all the civil charges as well. Case law shows that if Oasis solely possessed the rights of ownership over money loaned to it under the terms of the Promissory Note and Agreement and risk disclosure, then lenders of that money cannot be legally identified as investors. Under law, commodity pools, as statutorily defined and necessarily operated under the CFTC's authority, must be composed of investor money. Absent investor money, no commodity pool subject to the CFTC's regulations can exist. If no pool was formed, then the charges brought against Oasis for illegally operating commodity pools without the CFTC's authorization are void and without merit, and there is nothing to support any of the counts brought in the civil case. Because Oasis wholly and exclusively owned the funds in question, it did not operate commodity pools and was outside the jurisdiction of the CFTC's authority. Michael DeCorta's agreement with the NFA to never again apply for membership after August 9, 2010, was not breached, and since he didn't operate his company under the authority of the CFTC, his 2010 NFA agreement was entirely irrelevant in either the civil or the criminal case against him. By contrast, if Oasis did not own the funds loaned to it, then the lenders were actually investors who retained an interest in the loaned funds, which would strongly suggest that the way Oasis used them constituted an illegal commodity pool operation in violation of CFTC regulations. To determine which party had ownership and control of the loaned funds, we need to analyze the terms of the Promissory Note Loan Agreement and risk disclosure, signed by lenders before their money was accepted by Oasis International Group, and then refer to pertinent case law on the question.
With respect to ownership of the funds. 1. Transfer of ownership. The Oasis Promissory Note and Agreement clearly shows that the lender was loaning money to Oasis on a short-term unsecured basis, meaning that the funds were transferred to Oasis without any collateral. Thus, ownership of the funds was transferred to Oasis as soon as they were loaned, which is to say, once they were accepted from the lender. We understand that no funds were accepted until after a lender signed the agreement and risk disclosure. On page 4 of the agreement, we read as follows. Paragraph 1. Short-term unsecured loan. By signing the promissory note and loan agreement, lender is loaning Oasis money on a short-term unsecured basis. There is no collateral provided by Oasis to the lender in connection with any money, including any interest thereon, loaned to Oasis by lender. In the event Oasis should become insolvent, it is possible that you would lose the entire amount in your account. Paragraph 2. Loans and withdrawals. Any loan made by you will require that you complete or update the information on the application so that a promissory note and loan agreement can be generated for acceptance by Oasis. With respect to ownership and control of the funds, please note the following. First, the contractual stipulation that Oasis had the discretion to use the loaned funds for any purpose, including investments, purchases, or general company use, without prior demand or notice to the lender, supports the notion that Oasis had ownership of the funds once they were loaned. Second, the agreement clearly gave Oasis sole discretion over the use of the funds, including the ability to sell, pledge, rehypothecate, assign, invest, commingle, and otherwise use the funds as it saw fit. This indicates that Oasis had control over the funds once they were loaned. Third, the lender did not retain any claim or right over the funds once they were loaned to Oasis, reinforcing the fact that Oasis thereafter had control over them. On page 5, the agreement concludes with the clear and unequivocal statement that Oasis shall have the right to sell, pledge, rehypothecate, assign, invest, commingle, and otherwise use any money loaned to it by lender, including any interest thereon, free from any claim or right of any nature whatsoever of the lender. On pages 4 and 5 we read as follows. Paragraph 3. Use of funds. At any time in Oasis's sole discretion, and without prior demand or notice, Oasis may use any or all money loaned by lender, including any interest thereon, for any purpose whatsoever, including without limitation any investment. The purchase or sale of foreign exchange products, securities or commodities, exchange or off-exchange products. The purchase or sale of any business's assets or liabilities, the purchase or sale of any real estate, or for any other purpose, including any general company use or payment, any company payment or loans to any company affiliate, officer, employee, or third party, any company indebtedness or other company obligations. Lender hereby agrees that Oasis may, at any time and from time to time, in the sole discretion of Oasis, apply and transfer from any of lender's funds with Oasis to any of Oasis's other accounts, whether held at Oasis or other individuals or entities in connection with any Oasis investment. Lender hereby authorizes Oasis to sell, pledge, rehypothecate, assign, invest, commingle, and otherwise use any money loaned to it by lender, including any interest thereon. Where lender's loan account consists of more than one loan, this authorization shall apply to all loans, including any interest thereon. Anything to the contrary notwithstanding, including without limitation any rule, regulation, or law, Oasis shall have the right to sell, pledge, rehypothecate, assign, invest, commingle, and otherwise use any money loaned to it by lender, including any interest thereon, free from any claim or right of any nature whatsoever of the lender. The agreement includes risk disclosures that highlight the speculative nature of Oasis's investments and the potential for loss, which each lender acknowledged and accepted as his or her independent decision by signing it. This further confirms that by signing the agreement, the lender relinquishes control of the funds to Oasis. Conclusion. Based on the terms of the Promissory Note Agreement and risk disclosures, Oasis International Group had both ownership and control of the funds once they were loaned by the lender. The lender's rights were limited, and they did not retain any control over the funds post-lending. Our conclusion is supported by case law. U.S. case law supports our conclusion that a borrower has ownership and control of funds once they are loaned in the manner described in Oasis's Promissory Note Agreement and risk disclosures. The terms of the Oasis Promissory Note and Agreement explicitly allowed the company to use the loaned money for any purpose, including selling, pledging, rehypothecating, assigning, investing, commingling, and otherwise using the money free from any claim or right of the lender, C.L. Cadem versus Equity Securities Corporation. This indicates that the lender has relinquished control over the funds once they are loaned to the company. Several cases support the conclusion that a borrower has ownership and control of funds once they are loaned, as described in the Oasis Promissory Note Agreement and risk disclosures. These include the following. 1. In El Cadem versus Equity Securities Corporation, the court noted that the agreement allowed Nationwide to rehypothecate the collateral and use it for its own business purposes without any restrictions from the lender. This is analogous to the Oasis situation, where the company could use the loaned money without any restrictions from the lender, pursuant to paragraph 3, use of funds on page 4 of the agreement. 2. North Avenue Capital, LLC versus Ranger Scientific LLC, highlights that funds in an account controlled exclusively by the lender do not benefit the borrower until disbursed. The Oasis agreement authorized the company to use the funds immediately upon their disbursement and receipt after the promissory note agreement had been signed, and for any purpose, indicating full control by Oasis. Third IP of a West 86th Street, 1 LLC versus Morgan Stanley, Mortgage Capital Holdings LLC, further supports this by showing that the lender can assign its interest in escrow accounts to a third party, and commingling of funds is permitted under the terms of the agreement. This reinforces the idea that the lender had no claim over the funds once they were loaned to Oasis. 4. In National Life Real Estate Holdings, LLC versus Scarlato, the court recognized that loan proceeds do not remain the property of the lender. The court stated that undertaking an obligation to repay and agreeing to conditions in loan documents do not make a debtor a trustee for the creditor, and the creditor does not remain the owner of the proceeds by virtue of these conditions. This indicates that the borrower gained ownership of the loaned funds. This accords with the agreement's provisions for repayment of the loan under paragraph 1. Interest found on page 1, and with the statement that Oasis is not acting as an advisor or serving as a fiduciary to lender, found in paragraph C on page 6. 5. In Collins v. Union Federal Savings and Loan Association, the court held that a loan is disbursed if the borrower has control over the proceeds. This indicates that once the borrower has control over the loan proceeds, they are considered to have ownership of those funds. 6. In Co v. First National Bank and Trust Company, the court stated that one of the elements of a loan is the delivery of money, so that the borrower may exercise dominion and ownership over it. This reinforces the idea that the borrower has ownership and control of the funds once they are loaned. 7. In re Conduct of O'Byrne, the court similarly noted that a loan is made when the borrower receives money over which they exercise dominion and which they promise to return, emphasizing the borrower's ownership and control over the loaned funds. These cases collectively support the principle that once funds are loaned to a borrower, the borrower has ownership and control over those funds, subject to the terms of the loan agreement. Therefore, case law studies confirm that Oasis owned and controlled the money loaned to it by each lender, free from any claim or right of the lender.
Both the civil and criminal cases against Michael DeCorta were based upon the false assumption that Oasis's lenders retained a proprietary interest in the money they loaned to Oasis under the promissory note agreement and risk disclosures. Both the CFTC's civil case complaint and the government's criminal case against Michael DeCorta consistently misrepresented Oasis lenders as investors, which, by law, they clearly were not. Yet it was absolutely necessary for the government and its agency to promote the fiction that lenders were investors who retained interests in Oasis's investments. If they could not maintain that fiction, neither case could have been tried. And, as we intend to show, neither of them should have been. The CFTC's civil case needs to prove that Oasis was in violation of statutory regulations regarding the operation of commodity pools. As the law shows, commodity pools are formed solely from investor funds, not company monies provided through loans under provisions like those in Oasis's promissory note. Without investor funds, no commodity pool can be formed. Since the loaned money was the exclusive property of Oasis, over which lenders had given its sole ownership, the company was free to use the funds in forex trading and to purchase real estate, precious metals, and businesses, free from any claim by a lender and free from the authority of the CFTC. This point was made in Michael DeCorta's appellate reply brief, document 45, filed October 8, 2024, in the 11th Circuit Court of Appeals, which specifically points out on page 6 that pooling cannot take place unless the lenders retained an ownership interest in those funds. Further reference was made on the same page to the CFTC v. Ammerman, 11th Circuit, holding in 2016 that the sine qua non of a commodity pool is the aggregation of investors' funds into a single account. And to the CFTC v. Equity Financial Group, LLC, 3rd Circuit, in 2009, holding that defendant was a commodity pool when he combined investor funds into a single commingled account. And to Lopez versus Dean Witter Reynolds, Incorporated, Ninth Circuit, in 1986, holding that factors to be present to find that a commodity pool existed are that an investment organization combines investor funds into a single account for the purpose of investing in commodity futures contracts. And to the CFTC v. Heritage Capital Advisory Services, Limited, Seventh Circuit, holding in 1987, that a commodity pool operator is one who solicits and pools the funds of others for the purpose of trading on the commodities market. The reply stated, "It is universally held that the investors must maintain an ownership interest in the funds invested in commodities in order for a commodity pool to exist." According to the loan agreements and risk disclosure agreements signed by all the lenders, the ownership rights of the lenders were severed. They did not have an ownership interest in those funds when they were placed in the Oasis accounts, and therefore there could not have been a pooling of investor funds. The CFTC's entire civil case depends solely on Oasis's alleged illegal operation of commodity pools. The government's criminal case against Michael DeCorta alleged that DeCorta and company perpetrated a fraud upon Oasis investors by failing to disclose losses that resulted from Oasis Forex trading activities. Since there were no investors, only lenders, and those lenders had each relinquished control of their loaned money to Oasis, the accrued trading losses had no bearing on the lender's relationship with Oasis or its responsibilities to them, which were defined by the terms of the Promissory Note Agreement and risk disclosure. Just as there could be no commodity pools formed from lender funds, there could be no fraud where no lender held an interest in Oasis's investments. Thus, since the genesis and definition of Oasis's relationship with and responsibilities to its lenders are clearly specified in the terms of the Promissory Note Agreement and risk disclosures, which every lender signed and by which they were divested of any interest over the use of their loaned funds. Nothing that happened as a consequence of Oasis investment activities, whether gain or loss, accruing from the disposition of the loaned money or the absence of any disclosure thereof, was a fraud upon any lender.